Today, the United States Supreme Court ruled emphatically against affirmative action. This ruling effectively bans the diversity programs as they are currently operated, meaning what we know as affirmative action is now over, ending, dead in public universities and other private colleges around the country. This ruling ends that program. It ends it at basically all public institutions, and we'll get into how the force of this ruling will affect people's lives, but guarantee it will affect you or people you know or students that you know in your life. 6 justices today voted to end the longstanding civil rights policy. The ruling came down in cases that involved 2 basically elite colleges, Harvard and the University of North Carolina. Republican appointees on this court declared the policy, which, to be clear, has been legal and constitutional and quite common for many decades in America, is now, as of today, as of this ruling today, it is now unconstitutional discrimination. Justice Roberts called it illegal discrimination. This is another sea change in a court that continues to upend rules in very specific areas. Not all their precedents, but very recently, and Nicole Walls and I just touched on this, in the areas of civil rights and women's rights, and often turning against longstanding precedents to get where they want to go. This ruling asserts that these changes are now, in the view of these members of the court, required by the text of the Constitution. And I will report for you tonight the new passages that are governing and binding law in America. In other words, this is the system. There's no further appeal past the Supreme Court. This is the law. And I'll share with you what that means. We also aim to tell you exactly the context for what's happening in our country right now. And I will also get into not only their impact and not only what the court says, but the obvious reality that what has also changed is what you see on your screen, the court's composition. 3 justices appointed by Donald Trump. You see some of them there and when he announced them. And those new members of the court, more than anything else that you can find in the text of the Constitution or the law, is what changed. In other words, political change, not legal change. And those Trump appointees have hardened the conservative bloc on this court. Now, to be clear, Justice Roberts has long opposed what are often called the remedial measures that drive modern civil rights policy in America. And this is not law school. I'm not going to go into all the weeds of it, but I'm going to simplify it and summarize it by saying that when the American system, through Congress and through its institutions like schools, has tried to address these problems, it has done so through federal oversight, through federal programs on the government side, the oversight of southern states, for example, dealing with attacks on voting rights and racism. But it was Roberts who used his position on the court to first undercut MLK's Voting Rights Act. He argued there, and this is relevant tonight, he argued there that the federal medicine had become worse than the disease. Now today, it is Roberts leading this more conservative Trump wing of the court to try to summon that logic to colleges today. And they are arguing that considering diversity at all itself is worse than the original discrimination that those diversity policies seek to mend. And to be clear, that position, which is now law, cuts against what a lot of Wall Street and corporate America, institutions, universities, the military, what a lot of institutions do. Roberts states that Harvard's affirmative action literally violates the Equal Protection Clause of the Constitution, and the programs employ race in what he calls a negative manner, and he asserts, quote, involve racial stereotyping. The argument here is that if you look at a place that has been largely white or male, maybe the majority of its entire history, a place like Harvard, and you say we want to be more aware of diversity, remedially, as I mentioned, to address that past discrimination, and for the future to have a diverse student body, that Roberts says, is the racism. That's against equality. Quote, the entire point of the Equal Protection Clause is that treating someone differently because of their skin color, he writes, is not like treating them differently because they are from a city or a suburb or because they play the violin poorly or well. Roberts basically writing that the universities did not carry their burden to prove their process was valid. Quote, it is far from evident how assigning students to these racial categories and making admissions decisions based on them furthers the educational benefits that the universities claim to pursue, end quote. That right there is the court basically telling the universities that they cannot run their own admissions and education programs the way they choose because the court has deemed them discriminatory. Now, again, that's the argument, and I'm showing you what the court said, and this will bind all universities. I will also tell you the problem for them with that argument is the people signing on to that opinion do not have a record in court cases in their judgments, or really in the rest of their public lives, of advocating civil rights or voting rights, or being taken seriously caring about the rights of minorities and women minorities who deal with the extra intersectional discrimination in these fields. These are judges who are using the language of equality, of the 14th Amendment, of a colorblind America, to join a movement that nobody thinks they're a part of, because these are not civil rights advocates in the racial sense. That's just a fact. Now, Chief Justice Roberts and these other Trump judges have also basically gone down a road that was just discussed here with the president and Nicole Wallace, which is reversing precedent. And there's real life impacts here. Now, affirmative action has already been eliminated at the local level by certain states. In other words, just as Harvard chooses to do it, some states have chosen not to do it. But that also has given us data on what happens. For example, the end of affirmative action in certain states led to a drop in minority enrollment at the top public universities in those states. Experts tell the New York Times the number of, for example, black students could drop to levels not seen since the 1960s at these selective colleges. Again, these are diversity programs that have been legal and used for many decades. In fact, when you hear talk about law and precedent, as recently as 2016, just within a decade ago, this was upheld in a form, not 100%, but basically a version of affirmative action was still upheld by the Supreme Court. And the other thing I want to tell you before we bring in our experts, and we have some civil rights leaders to respond tonight, is that we're not talking about something that is currently controversial. We saw the court enter into the abortion and Roe debate at a time when many of these issues had already been sort of worked out, and it sort of threw them back into crisis and controversy. We may see that again today. I cannot predict for you what will happen tomorrow or the reaction to this ruling, but I can tell you that for decades, a compromise has been worked out for affirmative action in competitive and elite institutions. Most schools, it's not an issue because most schools don't have this level of restriction. But when you get to West Point, where there's a carve-out we'll get to later in the show, or Harvard, you're making fine-grained distinctions because many more people could pass Harvard than are allowed to go to Harvard. And so you start picking and choosing. Not picking and choosing who can pass, but picking and choosing who gets to go there. It's in those areas where affirmative action and diversity has been so key, along the lines of race, geography, gender. And it is in that area now that we're seeing the court say, no, dead end. As for the history, we've had bipartisan coalitions for this. As I mentioned, Wall Street, the Supreme Court reaffirming it. This started back in '78 and recurred until the Trump justices got on this court. It recurred multiple times over the decades.
The Supreme Court of the United States ruled on two questions of decisive importance to all Americans.
Affirmative action is not dead, but has to be part of an overall program to diversify a student body.
Tonight, the Supreme Court has spoken. They have ruled affirmative action is here to stay, at least for now.
It's upholding the affirmative action at the University of Texas, Brian. It's a 4-3 decision.
I'm pleased that the Supreme Court upheld the basic notion that diversity is an important value in our society.
Over and over and over, the Supreme Court has upheld the basic precedent. And we are living through a very tough time for the Supreme Court. Some of the most withering pushback came from within the court. Justice Jackson, with a scathing dissent that talks about some of the issues I alluded to, that the conservative arguments here may not hold up. Quote, with let them eat cake obliviousness, today the majority pulls the ripcord and announces, quote, colorblindness for all, but deeming race irrelevant in law does not make it so in life. And having so detached itself from this country's actual past and present experiences, the court has now been lured into interfering with the crucial work that institutions of higher learning are doing to solve America's real-world problems, she writes, summarizing the ruling and its impact as a perverse, ahistorical, and counterproductive outcome that is a tragedy for us all. Justice Sotomayor, writing the devastating impact of this decision, cannot be overstated. When you look at what we're hearing here from within the court, it is, well, quite harsh. some justices reading their dissents from the bench, one of the rare ways that they sort of mark an extra strong dissent. We're dealing with a very ugly history that we've all lived through. Racism appears in many forms, in many ways, in this country and around the world. But America's specific problem is not just racism like bigotry or fighting among groups. America's problem, and we've talked about this many ways, and here we are tonight talking about the Supreme Court apparently blind to it in a week where we're hearing about blindness and colorblindness. America's specific problem is being a government and an alleged democracy founded on racism, state-sanctioned, and stitched into the very fabric of our founding documents. The Three-Fifths Compromise, the racism of slavery, the 14th Amendment, finally brought to address, allegedly, some of these issues being cited today by the people against any consideration of race and diversity. So the problem is not just how we deal with each other, although there is that. The problem is deeper in whether we have a government that can actually deal with these issues so that we might yet one day transcend them.